Ngunnawal and Ngambri peoples as the traditional custodians of country on which you are all meeting today. I'm in Washington, D.C., and I must admit I know that the traditional owners of New York are the Lenape people, but I didn't quite look up D.C. For today, but acknowledge the traditional owners of the land I'm on as well. Pay my respects to their ancestors and elders past, present and emerging, and extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. I declare the public hearings of the Standing Committee on Social Policy and Legal Affairs inquiry into online gambling and its impacts on those experiencing gambling harm. In accordance with the committee's resolution of 10 August 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. Those present here today are advised that filming and recording are permitted during the hearing. I remind members of the media who may be present or listening on the web of the need to fairly and accurately report on the proceedings of the committee. I now invite members of the committee to introduce yourselves.
Kate Chaney, member for Curtin in WA. Thanks.
Hi, I'm Sam Lim from WA Tangmi.
Terrific. And Peter Murphy, who's chairing this committee, and I'm the member for Dunkley in South East Melbourne. I now welcome representatives of the Department of Infrastructure, Transport, Regional Development, Communications and Arts, and the Australian Communication and Media Australia to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear for the committee?
Pauline Sullivan, First Assistant Secretary, Online Safety, Media and Platforms in the Department of Infrastructure, Transport, Regional Development, Communications and the Arts. And that will be the last time I say that.
They just call it the department from now on.
Exactly. Brackets, the department.
Margaret Lopez, Assistant Secretary, Classification, the Department.
Adam Carlo, I'm the Assistant Secretary of the Media, Industry and Sustainability branch in the department, and I have the Gambling and Broadcast Regulation team in my branch.
Andrew Verdon, Director of Broadcasting and Gambling Regulations section in the department.
Good morning, Kathy Rainsford, General Manager, Content and Consumer Division, Australian Communications and Media Authority.
Good morning, Rochelle Zernama, Executive Manager of the Content Safeguards branch at the ACMA.
Jeanette Nola, Manager of the Interactive Gambling team at the ACMA.
Welcome and thank you all. Thank you all particularly for being there at 8 o'clock in the morning to give your evidence. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and tracks parliamentary privilege. Did anyone from the department or ACMA wish to give a short opening statement? We only have 3 members of the committee so far to ask questions, but I'm sure we can fill up the time with questions if you don't have too much an opening statement.
No, Chair.
No, thank you, Chair.
Okay. Well, thank you. And you have provided very detailed submissions and we appreciate that. I might ask just a couple of questions and then, as you can hear, I'm struggling a bit with my breathing, and then I'll hand over to Ms Chaney and then Mr Lim, and if there's time afterwards, I can ask some more questions after that. Look, I might just start with this question. a lot of the feedback that we're getting as members of parliament is concern about advertising for sports gambling, both on free-to-air streaming services and on the internet, that seems on the face of it to comply with the current laws and regulations, but is being described as pervasive and invasive. I understand there's some research that would suggest that one of the unintended consequences of changes to the laws in 2017, which restricted advertising of betting odds and sports betting during live sports broadcasts during certain times, particularly when children watching, has been a proliferation of those sorts of ads in other times. So this is probably a question for the department. Is that correct? What research has been done on that? And a follow-up to that is what research, if any, are you aware of, either here or domestically, about increases in the advertising leading to increases in not just betting, but betting which causes harm?
Ms Murphy, it's Adam Carlon here. I might start and then I'll see if Andrew has anything else to add. So I'll be clear up front, we ourselves, the department, hasn't done any research that looks at whether or not there's a causal link between those IGA provisions and the increase in gambling advertising. What we do keep an eye on is advertising expenditure. There's clearly an increase in advertising expenditure. There's somewhere in the order of, I have it here at the moment, but somewhere in the order of an increase by 139% over the decade in advertising expenditure, from 120 million to 287 million in 2021. So clearly there's an increase in the money that's spent on advertising, which, as you would imagine, is reflected in more ads on television and other streaming platforms and other radio, etc. So we haven't done any research to determine whether or not there's a causal link, and I'm not aware of any research that indicates that there's a causal link between those two things, is probably the short answer.
Okay. Do you have any evidence or an instinct as to why over the last decade there has been that increase in both the payment for ads and actual ads for online gambling?
I don't. So this is an opinion, and there are some reference to this in some of the literature that I've read. But effectively, gambling's easier at the moment because we have smartphones, right? So the increase in people's access to gambling has been facilitated by the use of apps from a number of gambling providers, and I suspect that the incentive to get people to use those apps is gambling advertising, right? So that's again the short answer. We don't have and haven't done any research that can give us some actual data on that.
And if I could add, in the last 10 years, a number of operators have entered the market. Maybe about 10, 15 years ago, you might have only had one or two operators, but a number of online corporate bookmakers have entered the market over the last 10 years, and they've been obviously trying to get their market share, and that's where there's been an increase in the advertising on TV and across other platforms over the last 10 or so years.
And that would indicate, wouldn't it, that they believe it's a lucrative market with profits to be made?
Correct.
Yes.
Definitely, because Australia is the number one, got the number one losses in the world, unfortunately, but Australians do love to gamble, so it's an attractive market for overseas
bookmakers. Number one losses
and
per
number
capita.
one losses. Sorry, I interrupted you. Go ahead.
I was just just clarifying, number one losses per capita.
Yeah. And number one losses per capita doesn't mean that we're particularly bad at gambling. It just means we gamble more, right?
Correct.
Yeah. And the second half of my question, given that we know there is more advertising for online gambling, and as we've just discussed, it stands logically to reason that the corporations are advertising because it will lead more people to use their services. Do we know how that's correlating to harm from gambling? Or causing more harm from gambling?
Well, as you're no doubt aware from the appearance from our colleagues at DSS, they clearly keep a closer eye on the harms associated with gambling and are probably more across that research. Again, we haven't done a comparative analysis of the harms that may have been in place 10 years ago compared to the harms that are in place today, but just by the sheer fact that the market's increased and more money is being spent on gambling now than before, one would assume that those harms could have increased as well, but I can't say that definitively because we haven't done that research.
But again, as sort of the department responsible for the regulation, putting aside changes in the laws and what impact that may or may not have had, it must be the case that you have evidence that there has been a stark uptick in online gambling over the last decade in Australia.
Yes, and I suppose the one bit of data that we do have, or the something I could talk a little bit more about, was that we have seen an increase in complaints, or at least correspondence, to the Minister and to the department around that sentiment of that you mentioned earlier around the pervasive nature of gambling advertising on television. So I think there's an uptick in that, as there has been an uptick in gambling advertising expenditure and an uptick in number of gambling providers in Australia. So all of those elements are increasing. It would be unusual to think that the harms wouldn't correlate with those same sorts of increases.
Yeah. I was going to ask a question about loot boxes and gaming, and then I'll hand over to Ms. Chaney for a while. Is there work being done at the moment within the department or contemplated in response to the Australian Institute of Family Studies research about the connection between in-game purchases, loot boxes, simulated gambling and harm? Because it seems to me that that's fundamental to the question about whether we need to reform the regulatory regime for loot boxes and in-game gambling simulation or not.
Yes, Chair. So from a classification perspective, yes, we are looking at that research and the implications that it might have for classification.
Is that all though? Because classification, with all due respect, doesn't stop children or people under the age of 15 from accessing those games. It might give the parents more capacity to try to control it. But is the department looking at any other regulatory reforms? For example, considering that loot boxes and simulated gambling should be regulated in the same way as online gambling? Or how you would go about doing that?
From a regulatory point of view, quite simply, it would be amending the Interactive Gambling Act to broaden the definition of a gambling service. We haven't thought about drafting any legislation to that effect. To be honest, the one thing that we had been focusing on was the response, not the one thing, sorry, the many things that we're focusing on, but in relation to regulatory changes, was the proposal to ban the use of credit cards. And so, that's one element of the IGA amendments that we would make. Clearly, if we were going to go into the space of making an amendment to the IGA, we would then think about, are there any other amendments that we might want to make at the same time? But then this committee called this inquiry, and we thought it would be prudent not to. Yes, to help, but also not to rush ahead of what recommendations you might make, so that we can do it in a in a broader sense that picks up any other concerns that you may raise that this government wants to act on.
Are you able to assist us with any information about, I know the UK has looked at loot boxes, but other jurisdictions that are grappling with this issue, how they might be addressing it, whether there's been any successes or failures? You can take it on notice.
I was about to say, happy to take that on notice, Chair, and then we can come back to you.
That would be great.
Great.
Thank you. Ms. Cheney, are you right to go?
Yes, thanks very much, Chair. Thank you for your time today. I've got probably 7 questions on different topics, but and Chair, please stop me when my time's up. Firstly,
yes, well, I think there's only the 3 of us, Ms. Cheney, and we've got about another 40 minutes. So why don't you go for 10 to 12 minutes and we'll see how we go after that.
Sounds good. Firstly, given that in relation to free-to-air TV and radio, given the significant increase in gambling advertising over the last decade, and you mentioned the numbers, I think it's 2.6 times what it was a year ago, or 2.4 times overall. How effective do you think a self-regulation approach is through industry codes, given the large financial incentives for broadcasters to allow that increase in gambling advertising spend?
So at a general level, I mean, the codes themselves are largely effective, right? There are not a lot of breaches of the codes in relation to gambling advertising. Now, the question might be, are the codes set at the right level, and do they represent or reflect community expectations and community sentiment? And I think that's another question. There is...
Sorry, just to clarify then, when you say the code is effective, maybe you mean the code is being complied with,
yes.
But the question is whether that's effective
Correct.
to meet community
Correct.
standards.
Yeah. So there is an expectation that codes are reviewed on a regular basis, and I understand that there is some thinking about reviewing the codes in relation, just because of time. So, for example, I know as a fact that even the Community Broadcasting Association of Australia is reviewing its code for community broadcasters, and while clearly community broadcasters don't do a lot of advertising, no advertising, they do some sponsorship, and do very little gambling sponsorship, they have included a clause in the new draft code that's currently open for consultation that reflects that community sentiment about not advertising gambling at particular times, right, where they hadn't had that in previous codes. So there's an example of a code thinking about, or an association thinking about updating its code to reflect community sentiment. Are the other codes due for an update? Maybe they are. Maybe that's something that might come out of the recommendations that the committee makes, or it may be that the associations themselves think about it.
Thank you. Just to pick up that thread, we do have an expectation that the broadcasting codes are reviewed regularly, and indeed I think it was June this year, the ACMA published a paper which we refer to as What Audiences Want, where we set out our contemporary view of what the essential community protections would be for audiences in both in a platform neutral way. When that was released, we also called upon the relevant broadcasting subsectors, so the subscription sector, the free-to-air sector, the community sector, to look at that and to work with us to understand what their views around review of their codes were. As part of that paper, we did refer to what we saw as changing community expectations around gambling and what that might mean for gambling advertising, and we have asked them to look at that. We've had several conversations, in particular with the the commercial free-to-air sector, and we've recently spoken with the subscription sector as well, and we're of the understanding that they are both looking to review their codes in the course of 2023. And as I said, we've specifically asked them to consider what we set out in that paper, including looking at to what extent their current codes are meeting the expectations of their audiences around gambling.
Thank you. And I note that you said in your submission that most of the complaints that come through are about things that are actually compliant, but the community has different expectations. How specific were you in that paper in terms of scheduling and frequency of gambling ads and those issues being covered under the voluntary codes of conduct?
I don't have the paper in front of me. I don't think we were overly specific about that. In terms of how the ACMA works with the sectors that are responsible for their codes, ultimately it is their code. We've contributed this paper, which is published. It's a publicly available document, to be clear on our early expectations about the areas we think that they do need to look at. And in some areas, that's a little bit different for different sectors. As my colleague Mr. Carlin mentioned, so the community broadcasting sector doesn't do paid advertising, so what gambling protections look like for that sector, we would expect to look quite different to the commercial free TV area. The process of developing those or reviewing those codes and getting them updated, we expect that the sectors themselves will be informed by the evidence that their members have, so complaints that are coming through to them, some of which we don't see because they are resolved at a broadcaster level. Any research that they might do, and indeed they might commission some of their own research to better understand their audiences there. And then there's a collaborative process, I think is the best way to describe it, with the ACMA to work through particular provisions and drafting, with a view that ultimately when the code is put to the ACMA, we have to make a decision to register it, that we can be satisfied that it meets the legislative test, which I think is about providing appropriate community safeguards.
And has the ACMA in the past declined to register a code at any point?
Not that I'm aware of.
Right.
But I think that...
But I think it's fair to say, as Ms Rainsford has pointed out, that it's the process to get to that point is fairly iterative. It's there are multi-layers in consideration, and we take into account a range of factors. But yes, I don't believe in my time that the ACMA has refused to register. I think that the way that the ACMA would look to resolve that issue would be to get a code that could be registered, so that did meet contemporary standards of decency.
Right.
Sorry, contemporary standards of decency, meet appropriate community standards.
And how frequently, you said there's an expectation that those codes are reviewed regularly. How regularly is regularly?
It can depend a bit. There's no hard and fast rule. In some codes, the sectors themselves flag that they would expect to review codes within a certain time frame. I think the commercial free-to-air code was last reviewed in 2015. So we're several years on. The landscape's changed quite a bit. So certainly the ACMA has said that one's, we certainly think is up for review, and we've said the same for the subscription the subscription sector. I would note with the subscription television sector, I should be specific there. That sector had started a review which was put on pause when COVID hit, albeit we're now two to 3 years on. So we've asked them to go back and look at where they were in picking up that review in light of the What Audiences Want paper.
Okay,
I would
thank you.
also add that in 2018, the gambling provisions around live sport were updated. So the code was holistically, the free TV, the commercial television code was holistically reviewed last in 2015, but all sectors updated their codes in 2018 to include additional supplementary gambling advertising protections around live sport.
Thank you. I want to move on now to that shift in community expectations and changes in viewing behaviour, where certainly my kids don't really distinguish between online and free-to-air or TV or subscription. It's all much of a muchness. And certainly the feedback I've had from constituents is that it seems that there are gambling ads through sport all the time, and perhaps that's because they don't happen to be watching it on free-to-air TV during the specified hours. I'm interested in a few things. Firstly, understanding the online simulcast exemption and exactly how that works, to start with.
If I might, I'll just before Ms. Zernama talks about that exemption, without knowing the specifics, specific examples in there, I just the rules around or the current prohibitions are essentially the same between the online and the terrestrial broadcast world. So I suspect the distinction that you're referring to there relates to live sport versus non-live sport. So the prohibitions that are in place only apply to the broadcast or streaming of live sport events. And of course, there is lots of non-live sport that is available in Australia on both platforms, which are not caught by the current prohibitions.
It may also be that because there is an exemption for breaks in live sport, like half-time, that people consider that to be broadcast during live sport.
Yeah. Yes.
Yeah.
Oh, yes, certainly. There are certainly some allowances in the existing rules in sport in live sport in some.
After 8:30. So before 8:30, there is no allowance for an ad during a scheduled break. There should not be ads broadcast during scheduled breaks.
And that's the same online or broadcast?
Correct. If in conjunction with any online material broadcast in conjunction with live sport, should be applying the same rules.
Right, okay. It feels like a huge gap to me that the general feeling in the community seems to be that there is online gambling advertised during live sport, and yet, I then hear that it's not, and I can't reconcile these two perspectives.
And Ms. Chaney, do you mind if I just jump in and say, I agree with you on that, and I watched one of the AFL, whatever that was, preliminary finals at my mother-in-law's house on a Saturday afternoon, and absolutely that was on free-to-air television because she doesn't have anything else, and I saw gambling advertising at a time when it shouldn't have been there. I know I didn't imagine it, so the feedback we're getting from our constituents, and I know the ACMA, you regulate it, and it's something I'm sure that if someone's made a complaint will be investigated, but anecdotally it just does not seem that what you're saying is the law and how it's applied is what we're experiencing.
Yes, I'd agree with that, Chair. I want to move on to the fact that you can't regulate even non-licensed interactive gambling providers on global platforms. So, Facebook, YouTube, etc., if they're not designed to be for an Australian audience. What do you think the effect of that is, and what are some alternatives that could be possible?
Jeanette Noller. from the ACMA. I think you're referring to our comments in our submission around the advertising prohibition in the Interactive Gambling Act.
Yes.
And that prohibition is on publishing a gambling ad on a website. And we have to be satisfied that the people who are viewing that website are predominantly from Australia. So for those global or those services that have a global audience like Facebook and Google and the like, it would be very difficult for us to reach that conclusion. So the proposition that we're putting forward is that we could look at that prohibition and whether or not that requirement is necessary for us to make a contravention finding for an advertisement that's gambling related, which is on one of those type of services that has that global audience.
And is it actually practical to, if that exemption was removed and you were able to make a contravention finding, is enforcement of that practical?
A lot of these services have their own guidelines in place, and so raising a contravention or content which we think is contravening with those service providers, they will remove it themselves. So to be able to make that finding is a useful thing to be able to do. We would also be looking at removal of the specific content, not all of Facebook or all of the global platform. We would be looking at the contravention finding against the pages that were found to be contravening.
Okay, thank you. And just one last question for now in relation to BetStop and the ability to, or the requirement to verify customers within 72 hours. And I understand that's a significant reduction from how it was previously, but what's the reasoning for actually allowing customers to place bets immediately before customer verification at all?
Those requirements around the verification within 72 hours are actually requirements under the anti-money laundering legislation, which the ACMA is not the regulator for, and indeed actually sits in a different portfolio. AUSTRAC's the relevant regulator there. So I'm in terms of the rationale for that policy, I think that is one for a different portfolio. Of course, that was a measure under the National Consumer Protection Framework, so Department of Social Services would likely have some insight into the rationale for that change.
Right, but you do suggest that, or maybe I can ask then, can you give some more context to your suggestion that wagering providers should be required to verify customers before allowing them to open accounts?
Sure. Certainly. I think my starting point there would be the interaction between the regime that will apply once BetStop is live and the anti-money laundering regulations has caused quite a bit of confusion in industry. And partly that is because once BetStop is live, the regulations will mean that a licensed wagering operator is not able to open an account or take a bet from or direct market to an excluded person in there. Now, in order to comply with that, we would expect that the wagering operator is doing some level of identity verification so that if they were checking against the details that will be available that are on BetStop, so who is excluded, there is some integrity in that data matching there. That said, at the moment there is no requirement to do there's no legal requirement to have done the same check that is required for the anti-money laundering regulations at that time. Now, we're certainly aware that there are some operators who are moving to checking before opening the account. So they will do, if you like, the anti-money laundering check right up front. They won't take advantage of that 72 hours because it streamlines their operations and makes it easier for our end. But there is a slight difference at the moment in what the minimum obligations would be there, and so it would provide, I think, greater clarity for industry and consumers about what information and checks will be done on opening an account, and simplify meeting both of those obligations.
So we know it's possible. It serves two purposes, both a money laundering purpose and a self-exclusion purpose. And there's nothing specific about 72 hours that means that it is practically required.
Oh, well, certainly not from a bet stop perspective, but I couldn't comment on what the policy drivers are from a money laundering and terrorism financing perspective.
Okay, thank you. Chair, I'll leave it there for now. Sorry.
We didn't answer your question about the online simulcast.
Oh, no, you
exemption.
didn't. Tell me about that.
Would you like me to briefly address that? It's a little ambiguous that it's called an exemption, because essentially what it does is it's designed to allow a service that provides both a broadcast feed and a online feed of the same material at the same time that is identical. If that happens, and the only services that do that are commercial television and commercial radio services at the moment, and the idea is that they'd be subject to one set of rules, not two. So if the service is identical, they will be covered by the broadcasting codes, and they will then be exempt from the online service provider rules. So we won't essentially ping them under two sets of rules, but it has to be exactly the same content. So it doesn't mean that content is not covered. It means that as long as it's covered under the broadcasting codes, it doesn't need to be covered under the online rules as well.
And sorry, just to clarify then, what would be the difference between the online rules and the broadcast code for that same piece of broadcast?
The rules are essentially the same. The substantive rules are essentially the same. It was more of an administrative thing around not having two sets of rules applying to the same entity or the same piece of content.
But the rules are the same, whether it's broadcast on free-to-air or subscription TV or online.
Correct. They are substantively the same. There are a couple of additional record-keeping rules in relation to the online space because it's operated in a slightly different business capacity, but the core protections are the same.
Thank you very much, Chair. Thank you.
Thank you. Mr. Lim, do you have questions? Are you still there? I don't think. Oh, great.
Yes, I am. I'm having another meeting next door, so I put a very loud speaker so I could hear it from next door. I forwarded many questions. I just ask a few short ones, okay?
You've got about 10 or 15 minutes, Mr. Lim, so it's up to you how long you want to ask.
Yeah, but I got two customers waiting for me next door. Can the department outline some of the challenges of blocking illegal gambling website in terms of the ease of accessibility the internet provides? Is there more than can be done to detect or block these websites faster?
Jeanette Noller, ACMA. In terms of blocking the websites faster, we are alerted to services that people think are operating illegally through complaints and through our own monitoring. We'll investigate and then proceed if necessary or appropriate. We will block the websites if they're contravening. We continue to monitor those services and those sites, and if circumvention steps are taken and the operator sets up mirror sites, then we will move to block those mirror sites as well. There is a process that we have to go through to establish that the mirror site is a mirror of the original site that contravened before we can block, but it is a reasonably streamlined process that we go through to do that. So we are turning that around quite quickly in terms of monitoring, establishing the sites of contravening and then blocking. That's the response in terms of speed. There are obviously other issues with the efficiency or the effectiveness of blocking. It's not 100% effective, but we say that it is very effective as a disruption measure for the services. But there are ways to circumvent taken by the operators themselves, as we've just discussed with mirror sites, but there are also ways around the blocking that consumers can take as well.
Thank you. One more question. The Australian Communications and Media Authority was given additional power under the Interactive Gambling Act Amendment 2017. Since then, the authority has undertaken more than 470 investigations, which have led to a range of enforcement actions. Can the authority outline what this enforcement action entail?
We have a range of enforcement actions that we can take. They start with formal warnings, and we can also issue infringement notices. We have the option of seeking civil penalties in the federal court or seeking an injunction. We can notify regulatory authorities in overseas jurisdictions about contravening services as well. We can implement website blocking, which we've just talked about. We can notify Australian border forces with the names of the directors and principals of offending companies for inclusion on a movement alert list, which may affect travel plans of those entities into Australia. And we notify relevant providers of internet filters of the service URL for adding to their list, so they're included on those filter lists. So that's the range of the enforcement actions that we can take. We mostly, as a first starting point, we have a graduated enforcement strategy. Mostly we will issue formal warnings to services if it's their first time contravening, but we will move to other enforcement actions. Predominantly that has been web blocking, and this number, as at the time of writing the submission, was 619 services or sites that we have blocked. A number of those relate to the primary site, others relate to the mirror sites of those services.
Can I just add to Ms Lim's question? Can you describe the sorts of contraventions that could be better addressed if ACMA also had additional powers, for example, to require behavioural or cultural change?
So one of the suggestions that is in the submission is that the Interactive Gambling Act includes the option for us to issue enforceable undertakings and remedial direction, to accept enforceable undertakings and issue remedial directions. They would be useful where we are able to identify the provider of the service, so that would really be for services that are contravening that are Australian-based services. But that would be useful in those circumstances.
Can you give some examples of of things that you've seen where that would have been a useful enforcement power to have?
I think maybe I'll start here. I think what's implicit in everything Jeanette has mentioned there is that it is useful for us to have a broad suite of powers so that we can, if you like, direct our enforcement decisions appropriately at the particular facts of a situation. But many of the tools that we've got are difficult to apply, if not impossible, in situations where we cannot identify the operators of a company, which is often the case when we're dealing with foreign entities who generally take extraordinary steps to hide themselves from regulatory authorities. If I look back on the last few years in our interactive gambling space, the vast majority of our efforts have been focused at the illegal sites, which we understand to be operating from overseas, and where those sorts of tools, because we can't identify who's operating them, would not really add anything material to our toolkit. I think it's fair to say, by and large, the licensed wagering operators in Australia largely comply with the rules. We've had very little cause to ever look into their compliance with the IGA. I think there was one investigation late last year about in-play betting, which resulted in us issuing a formal warning, and I consider that was appropriate in that instance. One of the things we're thinking about in terms of that suggestion we put forward in the submission relates to the role that we will have around compliance and enforcement when BetStop comes into effect. That regime is targeted at the licensed wagering operators who are known. We have a list of them. They're licensed in Australia by the state and territory regulators, and to the extent that there might be non-compliance with some of those provisions, the possibility of either inviting a core enforceable undertaking or being able to issue a remedial direction which is focused on things we often see in other aspects of our remit at the ACMA that we use those for are training, independent audits of systems and processes and assurances with a view to getting the entity into a state where we would expect sustained compliance going forward. Sometimes they can be very useful in that respect. I think the other piece that we called out in our submission is even though in many areas of our remit, including interactive gambling, we accept complaints, we don't actually have tools which would remedy the particular harm for an individual. So the complaints that Ms. Nola's team deal with, will come to us saying, I'm speaking fairly broadly, but I've used this service, I won some money, they won't pay it out. So there's been some loss or harm to an individual in some cases. We don't have powers to negotiate a remedy for a particular individual. Our focus is on the broader compliance issue. But certainly, as per the example in our submission, some enforceable undertakings in particular can be very flexible tools, whereby we have had some recent success in that case in our unsolicited communications jurisdiction in actually getting an enforcement outcome which balances both the specific and general deterrence aspects of our focus, but with something which in that case also provided some remedy for some individuals who'd suffered as a result of that particular direct marketing. So it's just a different tool in our toolkit which opens up some options which we think might be useful, particularly, as I said, when BetStop comes into play.
Thank you.
Can I just ask Mr. Lim if he has any further questions?
Last one, okay? Very easy to answer, okay? The legal distinction between games and gambling can appear blurry can the department describe the difference between these two in a legal sense? Is the department under the impression that expanding the legal definition of gaming or gambling will be benefit to consumers? Thank you.
I'm not sure, Mr. Lim, it's as easy to answer as you might expect. Effectively, games are not covered by the Interactive Gambling Act as a gambling service. Could they be? Yes, with an amendment to the Act. Should they be is the question, and there are arguments for and against, and you've seen those in the submissions that have been made already to the committee and to the inquiry. We will, of course, look at all of those, look at the recommendations that you make, and really that will be a matter for government to determine any action that we take in relation to those amendments going forward. But it's a relatively straightforward change in the Act itself.
All right, thank you. I'm just going to...
Before I go, I want to say thanks to everyone. You all spent so much time trying to explain to us. Thank you very much.
Participating, Mr. Lim. I have a couple of quick questions. We've got 6 minutes or so left. Obviously, big football codes, sports betting agencies sponsor names advertised on jumpers, but also there is advertising around the grounds, which might not be an ad saying, go and bet at the pub with your mate, but it's clear the name of the agencies. They're doing it to get their name out, and why that is not captured by the prohibition on advertising gambling and sports betting during live sporting broadcasts?
It's a very good question, Chair. If I turn my mind back a few weeks to the consistent gambling messaging consultation, extensive consultation that DSS undertook with both gambling providers but also with the media industry, it became very clear that that it's a complex environment, that there are aspects of interactive gambling that clearly the Commonwealth regulates through the IGA. There are elements of gambling regulated by the states and territories. But what was clear is that there is not necessarily that specific clarity on, how signage at stadiums, sponsorship on jumpers, someone holding up a sign in a crowd, how all of that's regulated, and the naming of stadiums is something else that you've mentioned. So,
Can I interrupt? Can I just
Yes.
ask you, so is there an argument that it actually currently is covered by the IGA?
No.
And for whatever
it's
reason
not- it's
that
not.
approach has been taken, or is it just there is something that means that it's not?
It's definitely not
Definitely not.
covered by the IGA because it's not it's not either a scheduling of broadcasting or a content or a code contravention. So it's not covered by the IGA or the BSA in those respects.
Could we make it? Could we tweak the IGA to say that any advertising of that form during live broadcast is prohibited in the same way that a scheduled ad is prohibited?
There are.
Probably I'd prefer to take that on notice, Chair, because, I'm conscious I'm not a lawyer and you are, but it really would come down to the scope of the comms power, the communications power in the Constitution. So happy to take that on notice, but that would fundamentally, obviously our power to regulate in this space is derived from that. So.
No, I'm very happy for you to do that. And I might put one of these questions on notice, but I've got another question. So as I understand it, the prohibitions on advertising during live sports that came in with the 2017 legislation, somewhere there's an exemption for breaking sport if the broadcasting about gambling and the odds is not occurring from the stadium. Is that ringing bells for anyone there?
There is a,
I can hear real bells ringing.
yeah, there is an exemption around commentator betting odds appearing at the stadium.
Yeah.
I will just check that I've got that in front of me, Chair, in the time we've got available.
Yeah, that's okay. My actual question is, I understand that a way around that and a loophole in that is to have the commentator discussion of the odds from a studio that's not at the stadium, so may well be around the corner. And I feel that may be an explanation for why people feel that there's odds being spoken about and sports betting advertising in its broader sense happening during live broadcasts, because it's happening during the broadcast but not from the stadium, so it is covered by an exemption.
That has not been brought to our attention via complaints, and we do, people do notice some things and complain to us about issues that are covered. So I'm not aware of that practice, Chair.
Can I ask if you just look at that and whether that is actually a scenario that's possible? Because as I read the exemptions, I think it may well be.
Yes, we can take that on notice, Chair.
Terrific. Just briefly, you can take it on notice if you like, but the Gambling Reform Alliance and others have talked about not just the potential for a national regulator and national gambling laws, which would obviously involve a lot of cooperation from the states and referral powers, but perhaps an online gambling or a gambling ombudsman who would have the powers to do some of the things that ACMA can't do, for example, negotiate money back or compensation for harms caused. Is there any view about whether that's a reform that is worthy of consideration?
Well,
You can take it on notice at the time.
I mean, for me, I'm always happy to look at, obviously any final decision on institutional changes and so forth would be a matter for government. I guess my question would just be, what are the different powers as opposed to what ACMA has, and do we need, and this would be a general comment I'd make about setting up new institutions, is it a case of we just need to give ACMA more powers, if that's considered the problem, or do we actually need to set up a separate body to do that? So that's a very sort of institutional type answer. But I guess it's always the question for me around what's about the need for more powers versus a new body to administer those powers. That would be my immediate reaction, but that's obviously not overly thoughtful. So, Kath.
Thank you. I note the time, and I've taken up what remained of the time. Ms. Chaney, I'm sorry, I wanted to come back to you for more questions, but we've taken up the time. So I'm going to cut you off. If there's answers that you wish to add to, please do. I have to read something out now formally. You have been asked to provide some additional information, and we'd ask that you forward it to the Secretary by the 14th of December 2022, and you may receive some further questions on notice from members of the committee, and you will be sent a copy of the transcript of your evidence and will have an opportunity to request correction to transcription errors. Thank you very much for your attendance here today, Ms. Chaney. Thank you very much for your participation, and I now declare the public hearing closed.
Thank you, Chair. Thank you.